All rise, vous le voulez. The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelé à exercer les fonctions résiduelles des tribunaux pénaux est ouverte. Please be seated.
Well, today the Appeals Chamber pronounces the judgment in the case of Prosecutor versus Javica Stanišić and Franco Simatović, pursuant to Rule 144D of the Mechanism's Rule of Procedure and Evidence. The Appeals Chamber presently pronounces the last appeal judgment in connection with cases originally within the ICTY's jurisdiction involving international crimes committed in the territory of the former Yugoslavia since 1991. During the events relevant to this case, Stanišić served as a deputy chief and later chief of the State Security Service of the Serbian Ministry of the Interior, which I will refer to as the State Security Service. Simatović was one of the State Security Service's senior intelligence officers. The trial chamber found that through organizing the training of and then deploying Serb forces in connection with the takeover of Bosanski Samac in Bosnia and Herzegovina in April 1992, Stanišić and Simatović aided and abetted the charged crimes committed in this municipality, which included, among other acts, arbitrary detentions, forced labor, beatings and torture, sexual violence, and murder against the non-Serb populations. The trial chamber sentenced each to 12 years of imprisonment. Stanišić and Simatović have appealed these convictions and their sentences. While the trial chamber found that the conduct supporting Stanišić and Simatovic's aiding and abetting convictions for crimes committed in Bosanski Samac also contributed to the common criminal purpose, it concluded that the prosecution had not proven beyond reasonable doubt that either shared the intent to further the common criminal purpose. Consequently, the trial chamber did not convict either on the basis of JCE liability. Through grounds 1 and 2 of Stanisić's appeal, he challenges the trial chamber's conclusion that the actus reus of aiding and abetting liability in relation to the takeover of Bosanski Samac has been established. The appeals chamber finds that Stanišić has failed to demonstrate that the trial chamber erred in law or fact in finding that his actus reus for aiding and abetting crimes committed in Bosanski Samac was established. Parts of round 1 of Simatovic's appeal allege that the trial chamber erred in relation to findings principally concerning his positions with the State Security Service and his conduct unrelated to events in Bosanski Samac. The appeals chamber dismisses these challenges, finding in most instances that Simatovic's allegation of error, if substantiated, would not lead to a miscarriage of justice or invalidate his convictions or sentence. In ground 1A, the prosecution admits that the trial chamber erred in law in assessing what constitutes a contribution to the common criminal purpose, failed to adjudicate or provide a reasoned opinion on alleged contributions, or otherwise erred in failing to find that Stanišić and Simatović contributed to the common criminal purpose to forcibly and permanently remove the majority of non-Serbs from large areas of Croatia and Bosnia and Herzegovina in ways beyond their contributions to Bosanski Samac. In ground 1B, it contends that the trial chamber committed errors of law and fact in failing to find that they possessed the requisite mens rea for JCE liability. The appeals chamber grants, in part, ground 1 of the prosecution's appeals and finds Stanišić and Simatović responsible under Article 1 of the Mechanism Statute and Article 7.1 of the ICTY Statute for committing based on their participation in a JCE. As a result, Stanišić and Simatović are liable for charged crimes committed by principal perpetrators whose conduct is attributable to Stanišić and Simatović or other members of the JC. Based on a review of the findings of the trial chamber and the relevant record, these include charged crimes committed in Bosnia and Herzegovina, in Bijeljina, starting at the end of March 1992, in Zvornik in April 1992, in Bosanski Shamac, starting in April 1992, in Doboj in May 1992, in Sanski Most in April and May 1992, in Chernobyl in July 1995, and in Sanski Most in September 1995. The Appeals Chamber also finds that Stanišić and Simatović are liable for a murder committed in Dajska Planina, SAO SBWS, Croatia, in June 1992. The Appeals Chamber dismisses Stanišić and Simatovic's appeal in their entirety, grants in part ground 1 of the prosecution's appeal, and finds Stanišić and Simatović guilty under Article 1 of the statute and Articles 3, 5, and 7.1 of the ICTY statute for committing, based on their participation in a joint criminal enterprise, first category, the following crimes charged under counts 1 to 5 of the indictment. 1, deportation, human acts, forcible transfer, and persecution as crimes against humanity committed in connection with the takeover of Bijeljina. 2, murder as a violation of the laws or customs of war, as well as murder, deportation, inhuman acts, forcible transfer, and persecution as crimes against humanity committed in relation to the takeover of Zvornik. 3, murder as a violation of the laws or customs of war, as well as murder, deportation, inhuman acts, forcible transfer, and persecution as crimes against humanity in connection with and following the takeover of Bosanski Shamac. 4, inhuman acts, forcible transfer, and persecution as crimes against humanity committed during the takeover of Doboj. 5, deportation, inhuman acts, forcible transfer, and persecution as crimes against humanity committed in Sanski Most in April and May 1992. 6, murder as a violation of the laws or customs of war, as well as murder and persecution as crimes against humanity committed in Chernobyl in July 1995 and Sanski Most in September 1995. And 7, murder as a violation of the laws or customs of war, as well as murder and persecution as crimes against humanity for the killing of Marinja Senasi in Dajska Planina, SAO SBWS, in June 1992. Sets aside Stanisić's sentence of 12 years of imprisonment and imposes a sentence of 15 years of imprisonment, subject to credit being given under Rules 125C and 131 of the rules for the 2,634 days spent in detention as of May 31, 2023. Sets aside Simatovic's sentence of 12 years of imprisonment and imposes a sentence of 15 years of imprisonment, subject to credit being given under Rules 125C and 131 of the rules for the 3,048 days spent in detention as of 31 May 2023, and orders that, in accordance with Rules 127C and 131 of the rules, Stanišić and Simatović shall remain in the custody of the mechanism pending the finalization of the arrangements for their transfer to the state where their sentences will be served. The case is then concluded and the hearing is adjourned.
All rise, voulez-vous lever?